This is Susan Schaab, certified legal nurse consultant, and I asked Susan if she would talk with us today about mass tort cases. So Susan, I know you've been involved in both medical device and pharmaceutical mass torts, and I know that there's a distinction. So you want to share a little bit about it? And first, let's talk about what do we even mean by mass torts.
Mass tort is different than class action. Sometimes they get lumped in together, but class action is really multiple plaintiffs in one single case. Mass torts are individual tort cases that are then brought together, because if they were tried individually, it would just overwhelm the entire system.
Right. So they're in mass. So it's
Right.
not a single medical malpractice case.
Each case stands on its own merit.
Yeah. But it's the kind of case where a certified legal nurse consultant needs to be prepared to be focused on hundreds or even thousands of cases.
Exactly.
Right?
Yep.
So again, I know you've done both device and pharmaceutical, and with devices, you've done vaginal mesh cases.
Yes.
So tell us a little bit about how you interface with these cases on behalf of the attorneys.
I was fortunate to come in on one of the smaller companies with vaginal mesh and helped work with the attorneys to develop the patient profile, which looks at when the device the mesh was implanted, who implanted it, what the issues around it were: erosion, pain, suffering, loss of consortium, and then how the problems were addressed, whether there was any surgical procedure, or if it was just sort of watch and follow up and estrogen.
So while every medical malpractice case or personal injury case is very unique, what I'm kind of hearing from you is that when we're involved in mass tort cases, and this is important for people to understand, that there's like a template that they're working with, and you call that the patient profile.
Yes.
But there's a template. So as the consultant, you're going in and you are looking for very specific elements and occurrences and variances and signs and symptoms. And I think that that's important, that you can be involved in helping to create that template of what they have to look for.
Well, and when you're screening the records too, it's important because, again, each case is individual and stands on its own merit. So sometimes the screening of these cases can be done quickly and in a shoddy fashion, so that individuals who actually have significant damages are lost in the shuffle. And that case will settle for a much smaller amount than if the actual damages are correctly ascertained and brought to the attorney's attention, and then that case can either be tried individually or it will settle for a much greater amount.
And likewise, it's important for people to understand, if you are working on hundreds or thousands of cases, the attorney might not want you to spend 50 or 70 hours on a single plaintiff. So
Yeah.
it's a different kind of interaction.
I have spent as little as a half an hour on one whole medical record, because the screening is different. If you're looking for a surgical intervention that was done to correct the vaginal mesh, you're screening 6,000 pages in an hour looking for the operative note and knowing exactly.
Yeah.
So it is not. Yeah, it is short time frame specific. It's almost more like data mining in some of the cases.
And that's why that patient profile template is so important, because you really do know exactly what you have to get in there and get focused on.
And that's what you want to market to the attorney.
I know you've also worked on some pharmaceutical mass torts.
Yes.
How is that different?
That requires a lot more analysis. The pharmaceutical case that I was on the defense side, which was a lot of fun, because the injuries are related usually to the black box warning, but we all know that medications work and work together and have adverse effects depending on what the patient is taking, all the other medications, what their medical background is. So those pharmaceutical cases, actually, on the defense side, you can knock a bunch of them out just by providing very detailed, extensive reports.
And when you say knock them out, you mean basically get the plaintiff to drop the case, right?
Yeah. Oh, yeah.
Okay. All right. I just want to make sure
Yeah.
people listening know what you mean by that.
Yeah.
All right. So give us maybe a tip or two, when working on mass tort cases that you think over the years and your own involvement, you've kind of learned that are important for anybody who's going to get involved in these?
You need to understand what phase the case is in. If you're getting involved in very cutting edge litigation that's coming up, like I talked to a CLNC who is interested in issues coming up with perfusion equipment.
Yes, yes.
That is like just starting. Like, she knew more about it than I did because she had been getting the information from work, and then she was going to seek out attorneys involved in that. That's a very early phase. Then there's the phase where you can come on where they're trying what they call the bellwether cases, which is putting forward an example case to see what the verdicts can be. And the plaintiff usually loses those first few cases, and then they start winning, and then they start winning big. And once they start winning big, that's when it goes more into the mature phase, where it's just a scramble to find as many of these injured clients as you possibly can. So the bellwether, the emergent phase would be extremely interesting, because if you can bring to the attention of these attorneys, that this is an issue that you've noticed based on FDA data and some other information, they can get a big jump on it.
So you can really, at the beginning, help them to set the stage and really develop strategically where they're going to go with these cases.
Right.
Whereas if you're coming in more on the back end of it, you're probably going to be working more on behalf of what they've already defined as their objectives. And as you suggest to me earlier, sometimes they might be a little off track. So
Right.
It's better if you're brought in on the early stage.
On the early stage, it's wonderful because you don't need to locate an expert, because there is only one expert who is addressing causation issues in these cases. So that person is already working with the firms on both sides. What you are doing in the earlier stages of the litigation is just really helping form the whole analysis and legal strategy that goes with it.
Absolutely.
People get excited, with the thousands of cases that come in later on. It's very quick. You're extracting specific information that is already kind of set in stone by the motion process and everything between defense and plaintiff and the judge. So there's nothing truly unique that you can find unless you find damages that actually will move the person to a higher level on the settlement grid.
All right. Susan, thank you so much for sharing
Thank
this
you.
information on mass torts.